on our website. But for now, get to the workshop.
Okay.
And calendar will come on. Okay.
Yeah, that's not enough.
But they said that you just look a few.
We run 200.
I have no clue. I'm missing a whole lot of set of facts.
Tuesday night.
Well, I mean, email doesn't have to
Wednesday night at Kaiser.
you send
And
something.
periodically on Thursday, we go to like 26.
You know, register. Because an email can be created.
I don't know.
Digital footprint.
Yeah, it's not easy. If you're using Gmail and you have, yes, there are big hackers in this world who can do things, but
I don't know. Well,
they can go more into it and be like, all right, log in front of us, in front of the jury, and show the actual email that you have. Let me see if everything in there is exactly how you showed in the printout. Yeah. Registered mail cannot be played with. I mean, anyone can open it and log, getting it a little bit slow. Yeah, your email, if you have an account, it's not destroyed.
that was protection. So that's not good work.
Yeah, I have emails for years back.
Wizard brain.
But you're holding it.
Yeah.
I'm saying, but you don't hold it.
Oh, if you delete your account, well, it's like if you're throwing your mail in the trash.
You let us
Oh, yeah, you can always speed up, you can always speed up and get the extra credit.
So they keep everything.
As long as you got your account active. It's like you throwing away a registered email in the trash, and it's gone now. How do I prove that? It's the same thing.
The e-discovery is different because people, when you have e-discovery, you hire firms like the one that I
I'm fading.
Go out, get a bottle of water, coffee, juice.
I had to make a phone call.
All right, let's start.
Yeah. I can start. Yeah.
All right. All right, let's go to patents. Well, I was an engineer. Yes. What is a patent?
I'm so sorry.
Class is back in session. All right, so a patent is a contract between you and the government. U.S. government or any other government, you file a patent. The contract says that we will give you monopoly for a certain number of years as long as you teach rest of the world what you're trying to do here. Don't keep it a secret. Teach us. Let people know. Let people learn. And in return, we will give you a monopoly for certain years so that people can learn from it, build on it, so the society can evolve in technology and science. So that's the whole premise of a patent. Okay? So what is it? It's not a right to practice. You don't have to do anything with it. If you have a patent, you can sit on it and sleep on it for 20 years till it expires. It's a right to exclude. What it means is, you don't have to practice, but I cannot practice it either. You can tell me, you're excluded. It's my car, I will not let you drive. It will sit in the garage until I live. But you will not drive, right? It's a right of exclusion. It's a property right. You exclude people from it. You don't have to practice. And then the contract is, you get the right of exclusion for a limited time. Now, limited time is different. For utility patents, it's 20 years. For a design patent, it's 40. So you get that exclusion right for limited years in exchange for a public disclosure that you teach everyone what you're trying to do so that society as a whole can learn and grow in the scientific area. Okay? That's the premise of patent. That's actually what is with patent.
Question. Yes, I have a question. Okay, in order to protect your property,
Right.
let's say I look at it like this, and to have maximum security, I've got a copyright, then I'll file for a trademark, and then the third one I get a patent. So now am I completely covered?
Yeah, probably. I don't know. I guess those are the only 3 intellectual property that you can get other than trade secrets.
Okay, so that would be
Rest
good.
if you're keeping a secret, so you've got all 4. So you're covered, I guess. I don't know. There's a lot more to know there before I can give you an answer. All right, who can apply? Right? The copyright was an author. But in invention, it's the inventor that has a patent. European contracts are different. There, a corporation can apply. You can be the GM or the president of a corporation, and your name can be on the patent, not in the US. So there is sometimes a lot of confusion. In US, it has to be the inventor. You have to be the inventor to be listed. Again, I can be an employee or a contractor. By my agreements, I may have to assign. And if I play like a bad boy, I don't want to sign the contract. I'm not going to sign the assignment clause or assignment on the patent. You can always take that contract to patent office and be like, I have the right to get this patent. This is mine. It was done under an assignment clause. Okay? You can always put somebody on to get it as long as you have an agreement saying that the assignments of all inventions, if you're working as a contractor or an employee, belong to the corporation or me. So you can do that. Again, inventors can sell, assign if they don't have already an agreement. It's like any other intellectual property, right? We've talked about this. It's like a property. You can do whatever you want with it. What you can do with a property.
Even if you don't actually have like a model or something that,
Not always.
no?
The law says, the law is enablement is a big part of patent law. Means if you can, a person of your skill set, means the invention is always related to the skill set of the inventor. Okay? So person with ordinary skill in the art, that's a technical term. So person of ordinary skill in your art, if you are, I don't know, take some trade, you're a mechanical engineer, or a mechanic, somebody with knowledge in that art. That person can read your patent and understand and do and build what you're teaching. You don't even have to have a model. As long as the person can understand with skill set as yours. That's the law. Enablement is the law. So if you're enabling someone to do, you don't have to have an actual physical model. But when in litigation everything opens up, you argue commas and full stops, it can become an issue. But as long as you are teaching someone how to do it, you're good.
Question.
Yes.
Is there such a thing as an employee contractor agreement contract?
Say that again.
Okay, okay, an employee contractor agreement contract. Say for instance, like she's having a problem with the person that she was dealing with, and she didn't get like a contract agreement, right? That's why she's fighting with that person over there. Is there such a thing? Is there a form that I could like, or is there a form I could get where I could have the contractor sign them, or do I have to make that form up myself?
No, okay, Google it.
Google?
Yeah,
Okay.
Google it. There are so many templates floating around.
Okay.
An office depot and those type of places. So
Yeah, and then there are
contracts too.
some that sell it for cheaper, like.
Where did she say I could find it at? Office Depot?
Office Depot, they have,
Yeah, nowadays there are a lot of
Contracts.
online companies that are like, hey, we will have you customize your agreement and do this, blah, blah, blah. There's a lot of things out there. You can Google it, you'll find so many things. Alright, so different kind of patents. There are three kind of patents. Utility and design I've already talked about. You can also get a plant patent. Right? Monsanto, the biggest seed company in the world. They have plant patents. They've destroyed so many farmers, but they use this, plant patents. Genetically modified seeds. Yeah, well, it is what it is, but they apply it right. They get plant patents.
Is that new or is that always?
Oh, it's always plant.
That's the
No, but that
Florida
means
tan,
the-
Florida
they
grass,
own a
invented by
plant,
the University of
genetic,
Florida.
information?
Say that again?
How can you own a plant on plant nature?
Oh, not a natural plant. There are laws against it. You
So,
cannot
so they
use-
own the genes, right?
They own the genes.
Okay.
You need to do something. Again, the basic premises of a patent law is it needs to be new, it needs to be useful if it's a utility, and it needs to be non-obvious.
So in other words, they own the plant that has a certain gene, but not the plant itself, if it doesn't have the gene, right?
Oh, you don't need to be a genetic engineer to do something. You can be like, hey, I have two plants in my farm, let me play around with it, let's see what the pollen does with this. And something else comes up, you have a plant patent. You don't have to be a very sophisticated person to get a plant patent.
Talking about Monsanto, I understand that they have patents in India for their seeds.
Oh, everywhere.
So they have actually gone into India and sued the farmers for growing their own crops there.
They tried,
And what happened?
it's not very successful.
Okay.
Aren't they doing that in the US too?
Yeah, they are.
Oh, US, they have blocked the
They're
market.
they're running out all the organic
They're-
farmers.
they're going after the farmers too.
Yeah.
But that's not the topic of today's
Oh.
presentation. We can go for drinks someday and complain about all these ugly corporations, but let's stick to the topic. All right, utility patents, all right, novelty, new, useful, non-obvious. And I'm telling you, I know what your questions are gonna start popping is non-obvious, oh, what's obvious? Don't go into it, theses and papers and case laws, you're still trying to understand non-obviousness, okay? Very complex topic. But understand the premise or the gist of what it is. Again, new is easy, it has to be new. You are creating something new, that's your product. Useful, if it is a utility, means you're using it for something, it better be useful, right? You have to say some use of it. And non-obvious in a very literal sense means, you know, if I have a chair and I put wheels on it and my chair can move, is it too complex? Is it like, was it existing somewhere already? Did I do something now? Maybe someone can get a patent with a chair and a wheel. But the premise is like, if it's so obvious, you know, that you did not create anything new or new use of it. I mean, chair with a wheel probably is not the best example. You created a use now, people can move easily. That's, you know, you
At some point, that was probably
Mobility.
applicable,
Yeah, absolutely.
but
But
Not
not
now.
anymore, but it's more about something that is so trivial that you combined and you never got anything new out of it. The results stayed the same as it was gonna happen even if, you know, anybody could do it. You're not gonna get a patent. Now, don't go more deeper into it, it's a very complex topic. If you wanna read about it on your own, be my guest. But that's all I'm going to go into non-obvious. Alright, so utility patents can be processes. So when I was saying a method patent, that's a process, right? Software process. Softwares fall under the process patents. There's a new case again in Supreme Court. They're trying to fight about if softwares can be patented. It's gonna keep going on. Every few years there's a new case, and Supreme Court keeps telling them yes, software can be patented, but again, use common sense. Don't make it so trivial that you could do 2 + 2 with 10 is equal to 4 and now you're building a software and saying, I'm going to patent this. It's not gonna work. You're not gonna get a patent. You didn't do anything to it, right? It's just too trivial.
Does that include a business process?
Which process?
Business, like the business model?
Business methods are process
And
patents.
Netflix, for example, is that what it means?
It can be, I think they have a patent on it. Business method patents are available. You can file a business method. If you have a business, you're going to create this novel idea of how to do business. Nobody ever thought about vending machines and the DVDs. They may have a patent, red box. But now everybody's trying to get vending machine with this, vending machine with this. It's done. Just get over it. They already got the idea, they got the patent. So now just because you're not gonna keep a DVD in it, but you're something else.
But in you say process, does it have to be automated, or could it be something like, oh, they have multi-level marketing, I mean, could that have been patented like in the past?
Again, you don't have to be a god to get a patent. You don't have to create a new matter.
But I just
We
wonder-
all use something that exists,
So
right?
that could have been something.
Yes, if
okay.
something is public domain, it's in public domain. You can use it.
Right.
If it is not in a public domain, go talk to the guy who has it. Be like, hey, I want to improve something that you have. Would you work with me? I'll give you a license. I'll give you some money. Let's work together on it. Do something. At the end of the day, we all are here to make money. It's a capitalist country. So, make a deal. But if you steal somebody's idea, they are going to be upset. And when somebody's upset, they hire me. So, all right, improvements. Again, you just ask the questions. Can you file patents on improvements? Absolutely. There's something called evergreening process in pharmaceuticals. Means they keep doing something very minute and keep extending the life of their patents. So, like aspirin. How long aspirin has been there? Right now, there's a patent on it because it cures heart diseases. That's a patent. Nobody used aspirin for curing heart problems. It's a new use of an existing product. They filed a patent on it. So, again, improvements can be patented.
But that's only probably as good as the advertising because aspirin's aspirin. Still, right?
Oh, yeah, but they got a patent on use. Nobody can, now they're going to come after you. If you said, oh, have my aspirin, that's why they say Bayer aspirin for your heart disease. Nobody else talks about it, right?
I don't, I
Bayer
didn't
is
notice
gonna
that.
come after you and be like, what did you say? I have a patent on it. You're not.
Yeah, but common knowledge is out there that daily aspirin doesn't matter if
Bayer
it's
may-
Bayer
Bayer
or
may have
whatever.
Bayer may have added
Store brands have them all.
oxygen to it. I don't know,
Yeah.
some air might have touched it. It's cures heart disease, so they have a patent. All right. All right, design patents. Again, design is different from utility. There is no use. It's just ornamental. So you take the usefulness out and you keep the new and non-obvious, and you got a design patent. Probably motivated by the automobile industries because they had to protect their ideas on how they design the cars, and they don't want someone else to use it. 14 years is a long time. Nobody, goes back and tries to use something. So they have design patents. Most of the use nowadays, like there are a lot of design patents for phones, cases. That's big use of it. Jewelry, it's a big industry for design patents. You come up with some new, twisted wires, and you're like, hey, this might be fine. Sorry, I'm a man, I don't know. Sorry if I offend someone. I don't know much about jewelry. But there's a design patent, I file design patents on jewelry. So you can file, those are, but it's purely ornamental. And design patents are they don't have so much buffer around it. If you're not doing what it looks like, you probably are not doing it right. So it's just a design. The biggest case recently, Samsung and Google, Apple.
Yeah.
If you ever see that it's like the phone, the design is just like simple, like the curved surfaces of it. They've been
Is that what they're suing about?
Yeah,
Well, the
millions of
icons,
dollars.
the icons too, Apple's.
Yeah,
they-
they're like, oh,
they
the
invented
look
icons.
and feel, but the design pattern was the one with the curved
Corners.
surfaces, and it was not square, and then the button
Oh,
here.
please.
No, really, huh?
They have the money, they're gonna fight, they can. Alright. Plant patents, I'm gonna go very briefly on it unless someone here is a farmer and they wanna create something and fight Monsanto. It's invented or discovered.
Be a big business.
You can invent something or discover, but it has to be asexually reproduced. You cannot be like, hey, I found something in the wild, I've never seen this before, my invention. No, that's not. If it's growing in the wild, it's not yours. But if it is growing in the field that you actually plow every day or something, and accidentally something is going on there, and you pick a plant, that's a patent. You have a patent on it because you've been working on that piece of land. But outside, on the wild, no. All right, that's enough. Boring talk.
Next one I have, Monsanto come and kill you.
What? I'm not big enough for them to go out, come out. Again, it's all money game. What else? All right, what can you not patent? You cannot patent laws of nature. You know, there's never gonna be a patent on E is equal to MC squared. That's a law of nature. Gravity, you cannot patent gravity. All right, physical phenomena, lightning. It's not, you cannot patent lightning. It occurs in nature. All right, abstract ideas. I have a perpetual motion machine. I guess that was the best I could come up with. But abstract ideas has no use. You know, you cannot get a patent on it. Right. Offensive to public morality. I have some fun with it. And you're from India?
Me?
Yeah. Or
Descent.
Oh, descent, but you know, there's never gonna be a patent on Kama Sutra police. That's not true. So, alright.
Force it.
So, they may have a copyright, but they cannot patent a post. Alright, so, this is interesting, medical procedures. This has developed over years. There used to be patents where you figured out how to cure something or operate on someone. There was a patent on your medical procedure, but then it was against, public health. Everybody had to be, if the invention was there and the doctor was practicing in Texas, everybody has to go there and work with him and pay him licensing fee. So it's against, the public interest. So Congress went back and said, you know what, although it's an invention, you did create something, you cannot get patent on the medical activity. You can get drugs, you can file the instruments, you can do other things, but not the actual procedure of curing the person. So you cannot get a patent. This is a legal term, medical activity. There's a legal definition. All right. I think I've already covered this. Utility in plant, you get 20 years protection. Again, there you have to file renewal fee, 3.5, 7.5, and I think 11 years. 3.5, 7.5, and 11.
Yeah.
And it lasts for 20 years. You can have a patent for 20 years. If you get a design, there is no renewal fees. You just pay one-time fee of allowance and you get a protection for 14. Yes, sir.
If you have one creation work that has both utility and design, do you have to pay separate fees for both of those,
Yeah,
utility and design?
I have filed patents on both.
On
Same
one
thing as design and a utility, because there were some aspects I wanted to cover and I couldn't get it through utility.
Oh, okay.
Because I couldn't come up with a use. So I was like, all right, you still want to protect this part of your idea, you file a design on it because I cannot come up with a use for it.
How's it work when I come up with a process, and that process impinges on 3 or 4 other people's patents that's gone before? I'm building on the work, but I'm using their patented processes, but implicitly to create a new process. Do I then have to negotiate royalties with each of them independently?
It's a very broad question, okay? again, everything exists, you don't make something new. But if it's an improvement, simple answer is if it's an improvement on those three processes, and you're improving this, and then combining them, then you have to get to that. But if you made something new, just because it was there doesn't mean it has to be. Yeah, again,
But they can't block me,
they very well can, and they make it. If you start making money, they find out, they will come out with you.
So these are non-renewable.
After 20 years, unless you're a pharmaceutical, you do something. I mean, evergreen process works in other industries too, but pharmacy is known for it.
Because they change the product somehow.
No, it's the same graph in a different model every year.
That's how
So you said up to 20 years, you can
Yes,
do
20
it,
years.
and then 20 years, that's it, you can't patent.
There
it
are,
longer
there are
than that.
sometimes you get an extension from 20 years because if it was going through FDA process, the government had an incentive for saying, okay, we were blocking you from using it, so we will give you some extra years. There is a very complex formulas, mostly chemical patent attorneys play with it every year and still they don't mess it up. So there are formulas on how much extension of time you can get. Any other questions? All right, how long does it take to get a patent? The most important question. It takes a while, 2 to 3 years minimum to get a patent. But it's like, should you not do it? Absolutely not. You should. Because the day you actually file, you get an application number. Although you do not have a standing or a right to sue someone, because you don't have an actual patent, you can always send them a letter saying that, hey, I have filed it. This is mine. The day I get my grant, I'm coming after you and you're on notice. Your notice starts from here. Today, I'm telling you, stop. Because my date of patent is going to be the date of my filing. So my damages can start from anywhere from that date.
Why does it take so long?
That's a process. It's a process. It takes a while.
So what's so different about that process?
Crazy.
Is it like they
Well,
have
the
to?
government has an incentive to actually do their due diligence and not to just give everybody, hey, file a patent, you get it, you get
Also,
it.
like they kind of pick and choose and look and see which one makes.
No, they go through every patent.
Also,
Every patent, yes, you get an office action, and I have not known in my small experience of being a patent attorney that they ever gave a patent on the first go. Generally, I've heard, I don't know if it's true or if it's a rumor, that first time they always decline. And I go by that as a law. I tell my clients, they tell me, hey, how much is it gonna cost? I tell them what the cost of the patent is, and I tell them for the first rejection. At least, there will be a rejection the first time. Rejection, objection, whatever different things they come up with. If you violated a law, or they think you missed something, or you did not explain, or there can be a lot of things. But they will come back and object your patent at least once.
Does that run the fees up?
Oh, yeah. I don't work for Red Cross.
I mean, not obviously your time, but I mean.
No, there's no extra fee unless you pass certain phase and you want to do something else. There are continuation fees that you have to pay after final office actions. Means this is office, patent offices, I've given you enough chances, this is it. But generally it's the third office action is the general for final office action.
If there's essentially what we're saying is a 2 to 3 month, a 3-year period where from the filing date to the publication date, how am I aware that what's being filed, that's black box? So if I could be working on something, you could be working on something,
Yeah.
you file, I'm not aware you filed.
No? Yes.
But after it's published, you as an individual.
Yes, the publication date is 18 months.
Yes.
In about a year and a half, your patent will be published and it will be accessible. You can go on patent's website
In a
and see.
fast-moving area, 18 months is a lifetime. It's 3 cycles and such stuff.
You may think, but not in the patent world. There are a lot of things filed. The first firm I used to work for, our client was GE Healthcare, one of our clients. And man, they didn't want to do a prior art search.
You did.
No, they were like just file. We were like a mill. It was a mill. that's all we did. Patent for GE, St. Jude, Tyco Electronics. That's
So I
all.
was just getting, they just waited for them to get, prior was, they didn't know what to do prior.
No, the thing is, listen, they're not stupid. They have done their due diligence. Once you are in the industry, you do understand what's going on.
You've got your IP maps and everything else.
Yeah, they have their own in-house attorneys. They've done some due diligence, but we were not. We were just. They never asked us to perform any search. There were some freedom to operate, different things we did, but that was not prior art search. But prior art search, either they were doing in-house or they just, whoever researcher was working on it, they know that they're great, they work on it, they live in it.
That's enabled, but in most cases, you get prior art search.
I have to, unless some client signs a waiver, I have to. I don't do patent work without a prior.
And that's normally US prior, so you'd have a European prior as well, you'd have a UPrint search and a US.
The search I do, I cover everything. European patents, WIPO, then I do Japanese patents, I do US
Reuters.
patents and applications. Delphion, LexisNexis, they're the databases.
What's the average cost of a patent?
I'm not gonna say it. I can tell you the fees the office charges. Oh, the office fees? They recently changed it. There are 3 fees now. Like one is called microentity, means you are the first time inventor or you have less than 4 patents, you don't make a whole lot of money or you are in academic industry. You have to pay $430. The next level is $750, means you make decent money. And, or you had, this is your 10th patent, I think 5th or 6th, you start paying them. So they start thinking you're a little more sophisticated and you're kind of an industrial. So you pay $750. And if you are a big company like me, I think it's $1,100 something.
Okay. Like you said, maybe I'll live long enough to get it.
Question,
If you don't
around
have
a project, you normally have one
some
big,
required
you
for
put a barrier. of
No,
patents.
You don't build a ship and then just one patent on a ship. You
Yeah.
patent not involve everything in
Everything.
yes, every possible novelty.
You let them fight over it.
All right, resource, again, USAPatents.gov, it's the same for both trademark and patents. All right, trade secrets.
HTTP?
Here, just USAPatents.gov, that's all you need. Yes, sir.
How strict are they on enforcing the parking meters out there in the parking garage?
I think they're very strict.
Are you
Is that a
seriously?
legal question, sir?
Except on the second floor I think is free.
I don't know.
Oh, really?
Yeah.
I was told to park on the first floor, I pay the meter, so.
I have no clue.
It says visitors.
If I get up, I don't mean to be rude.
No,
I'll
go ahead.
get your,
If you have to not get a ticket, that's good. All right, trade secret. I'm gonna go through this real quick. Sorry, we're already close to 8 o'clock here. So, common sense definition. As long as it's a secret, it's a trade secret. All right, that's how simple it is. All right, again, like you can break it down, it has to be confidential information and classified information, and you've done certain things to protect it, and there is an economic value in it. So those are the different elements of it, but the common sense understanding is if you can keep a secret, and you can protect it, and you can prevent others from running with it or doing something with it, then you have a trade secret. Again, you can do it with contracts and different things. You can legally bind people. Oh yeah, absolutely, the best example in the world. But the worst example, because why people like, why do I have to file a patent? Just keep it a secret. Look at Coca-Cola, they've done it for years. Yeah, they own an army of attorneys. They will descend upon you and take every last thing you own if you ever breach their contract or try to steal their trade secret. They will destroy you as you know your life. It will be over. But that's not a good example for someone who's a smaller business owner. Or, get 20-year protection if you can get a patent approved. 20 years. oh my God, how much monopoly do you want? It's a lot. 20 years, like nowadays, technology and life moves so fast. 20 years is a whole lot of, it's like 2 lifetimes. So if you can get a patent and you think, just do it. It's a little more safer. Think about it. Like, again, this is a legal definition that your information is there, and you did take precautions to protect it, and it has an independent economic value. Those are the minimum requirements. You're protecting some information. Nobody cares about it. Keep it. I mean, there's no economic value to it.
Sorry, when you talk about when you don't have to prove that the patent has any value, you just have to allow. It doesn't have to work. It just has to. You assume it works.
Say that again.
If something doesn't
Five
work,
till.
for example, I'm working.
Oh, it better
That's
work.
not right.
Yeah, I didn't say that. I said enablement. Means a person in that skill knows that it will work. After reading it, he can do exactly what you're telling. The question was, do I need to have a prototype? And I said, no, not in every case. But it better work, because if it didn't work, what do you have? All right, so how do I protect or how do I maintain a trade secret? Right? You have non-compete agreements, non-disclosure agreements. You bind your employees, contractors with agreements. You violate this, I'm coming after you. Right? So you have laws. You have state law. You have federal law. 46 states have the Uniform Trade Secret Act, and the federal protects you with the theft and misappropriation laws. So those are used for trade secrets. But think about common sense. I like to think practical, and I like to advise my clients in a practical manner. All right. So this is my practical spiel. So trade secret is only a secret as long as you keep it. Right? If someone independently comes up with it, do not steal your idea. People do come up with ideas. They think about it. You think about something, oh wow, this is so cool. And then you do a little bit of search and you find, oh, yeah, somebody did already think about it. But so people do think about it. If you have a secret, it's not a secret anymore, because someone other than you know it. And it's gone. Someone reverse engineers it. Right? How are you going to go after something who reverse engineers it? You're not Coca-Cola. You don't have that muscle to go after it. Independently developing it. Somewhere else. Like they do come up with things that we all think about. We as an individual do give ourselves a lot more credit than sometimes we deserve, but everybody has an intellect, and everybody comes up with ideas, and everybody constantly thinks about it. And I run into these people every day. They're entrepreneurs. Every day they're thinking about, oh, what do I do? This vending machine. Oh, I want to put this in vending machine. There are people doing everything nowadays. But sometimes you don't have to file a patent. You're probably not going to get it. Just build a business and run with it. Sometimes you do want to protect it. And most of the times it's the case you do want to build some form of intellectual property around what you're trying to do.
I have one last question.
Yes, sir.
Explain to me what a pending patent is.
Pending patent is the day an attorney or you file a patent, you get an application number. Means you use that application number and say patent pending. Means it's still pending. I do not have an actual allowance from the USPTO, the patent office, but I do have a pending patent. So if you do decide to go or cheat or try to do something I'm already doing, the day I get a patent, I'm coming after you. You're on constructive notice.
Okay, so as far as I'm concerned, on my game board, once I get a pending patent, then I can go ahead and start, let's say, getting some investors or start marketing it, and then I'll just wait until I get the actual patent.
Absolutely.
Okay.
But I will always advise, do get a patent before you actually talk to people. You can bind them with agreements and you can try to do it, but one section of the law says that if you do try to exploit it commercially, you have 1 year clock within which you need to file a patent. But that's only in the US. Again, a distinction from other jurisdictions, other countries, you don't have that. So if you are developing something that may wanna go international, you will not be able to get a patent in other countries if you had a public disclosure beforehand.
Apple just had the same case. They announced it here in the States, and they didn't, and Germany declined it because it was now public knowledge in Germany.
Public knowledge. Europe, Japan, they will not allow you if you even mention it. But again, practical consideration, how are you gonna prove
So
it?
patent pending is your.
You get an
covered from the
application
day you
number.
apply?
Yes,
The day-
application number, you use that and you say patent pending. Do not say patent pending and make up some number. That's against the law, and there are lawsuits. They do come after you for it, and there's a big fine for it.
So I have a question, and you can help me answer based on what I'm going to tell you. I have created a 140 item Engelbret's and Subzinski emotional terrorism questionnaire that is designed to identify individuals who